Welcome back. In this second installment of my conversation with John Mark Keyes, we focus on the question of statutory interpretation. How is it that one is to read a statute? So now you have a bill that's become an act or a statute. I assume at this point it's very straightforward. You pick up the instrument, you give it a quick read, and you know what the law is. Is it that straightforward?
It might be if you have a very simple law, but typically laws are not that simple. On average, a new act probably takes about 20 or 30 pages, if not more. And of course, if you look at some laws like the Income Tax Act, they consist of hundreds and hundreds of pages. So an act of Parliament, an act of the legislature can be a fairly complex thing. And typically it is, because it's dealing with some serious issues that need to be resolved at a national level or at a provincial or a territorial level. Laws are there to try to make society as a whole function better. They deal with major questions, major problems that are coming up in the functioning of society. And the law is there to help try to improve things. It's there to try to correct problems that may exist. And so it's the complexity of those problems often that determines the complexity of the law itself. In order to understand the law, you have to have a good understanding of what the problem is as well. And you have to work with those two sides. And so reading a statute, you could read it just for pleasure reading, but very few people read statutes for pleasure. They usually read statutes because they want to solve some practical, real problem in real life. And so what they're doing with the statute is they're trying to understand it, and they're also trying to apply it to some particular situation that needs a legal solution.
So how do you do that? How do you read the statute?
Well, the first step is, as you say, reading. You look at the words of the statute. You pay close attention to what they're saying. That's always the first step in trying to do something with a statute or with a regulation for that matter. But just reading the words is generally not enough. And maybe just to step back from that, I'll try to give you an explanation of why just reading words and running off and jumping to conclusions is probably not a good thing. What a law is doing is it's doing really two things. First of all, it's trying to communicate the will of the legislature, the legislature being democratically elected representatives of the people, who have decided that things should be a certain way. So first and foremost, that law is trying to communicate, that statute is trying to communicate something about what the law is. But the law itself is not necessarily complete, because we live in a country where those words form a basis for understanding what the law is. And so that written law is more than just a communication from Parliament. It is a source of trying to understand what that law is. And once Parliament and the legislatures have passed the bill, and once it's been given royal assent, their job is over in terms of how that law applies. At that point, it's going into an interpretive process, a legal process, which looks at, yes, the words of that statute, but it looks at it in a broader context of legal interpretation and approaches to interpretation, because the law also has to form a sound basis for people to understand what their legal obligations are. It has to be a reliable source of what that is. One of the features of our system of government is that we have a system of the rule of law, and the rule of law is a relatively stable body of law that doesn't change from day to day. It doesn't change at the whims of government ministers. People can read the law and rely on it. And so that's the other fundamental feature of laws, is that they are a source of trying to understand the law in and of themselves, quite apart from the fact that a member of Parliament or a member of the legislature may have given their assent to the law. And so really the whole business of interpreting and applying laws is it's a composite exercise. It's not just reading the words that have been approved by Parliament. It's also trying to understand what they mean in and of themselves in the context in which the courts interpret the law.
And so presumably if the task is to construe the law with an eye to all these considerations you've raised, there are maxims or principles or rules that might be available to an aspiring lawyer trying to understand what these words mean. Is that so, and what would those rules be?
Well, you're right. There is a very well-developed body of law on how you interpret law. The courts have been at this for a very long time. Statutes go back to the Middle Ages. And through all of that period, our legal system has developed ways of interpretation that start with reading the words, but they take into account other things, and they have also developed a series of approaches, sometimes called rules of interpretation, that they very often apply to try to understand what the meaning of that law is, what really the content of the law is. One of the best encapsulations of the approaches that the courts take is one that was put together by a fellow named Elmer Dreger. He was a former legislative drafter, and he was also a former Deputy Minister of Justice. But he also did a great deal of teaching here at the University of Ottawa. He taught the first courses in statutory interpretation here in the 1950s and the 1960s. And in trying to teach the approaches, the rules of interpretation, he did a lot of thinking about what they are, and he boiled it down to a particular approach that he called the modern approach to interpretation, that has now become accepted as the really the key approach that courts should take in trying to understand what legislation means. And he, in the first edition of his book on the construction of legislation, he formulated that approach to interpretation in the following way. He said, the words of an act are to be read, so yes, you start off with reading, they're to be read in their entire context and in their grammatical and ordinary sense, harmoniously with the scheme of the act, with the object of the act, and with the intention of Parliament. And that formulation of the modern rule is probably the most frequently cited approach in the courts in Canada. You see it cited hundreds, thousands of times, including in the Supreme Court of Canada. And his modern rule of construction is really the touchstone, the starting point that the courts in Canada use today to interpret legislation. It's really a synthesis of all of those other individual rules of interpretation rolled up into that relatively pithy phrase.
It seems quite abstract. How does it work in practice?
Well, let's start by unpacking the various elements, because there are a number of elements to it, and each of them is really important. They all work together. So the first starting point is the words of the act. The words are the primary vehicle for conveying meaning. And so you always start by reading them very carefully. But you have to recognize that individual words have different meanings. If you look at a dictionary, you typically find a half a dozen different meanings for individual words, and sometimes those meanings are very different. And so the question then is, when you're reading words, is which meaning is the right meaning here? How do you arrive at that meaning? And that's why Dreijer went on to talk about the other elements of this approach to interpretation. And the first one is, of course, reading in its entire context. So context plays a critical role in understanding what people mean when they use words. We use it all the time. It's a way of making verbal communication more efficient. And we use it especially in speech, but it's also something that comes up in written communication as well. A lot of things don't have to be said, and that's what is formed by the context. So as we're talking here, Craig, about things, I'm not being as explicit about what I'm doing because we have an understanding of what we're trying to accomplish here. We are preparing an audio presentation on statutory interpretation for students who will be beginning their studies at the University of Ottawa. That's the context for what we're talking about. If the context were different, if this were something that we were going to be broadcasting generally to the world at large, or if it's something that we wanted to present to students at the high school level or in some other forum, we would be adjusting what we were talking about. We wouldn't be saying things in the same way because the context would be shaping what we're doing. Well, it's the same with all communication. There's a certain context around that communication, and with legislative communication, some of the features of that context are things like an interpretation act, or they're things like the drafting conventions that are typically used to draft legislation in Canada. Every jurisdiction has an interpretation act, which contains a whole series of rules of interpretation, and they often contain definitions of key words. So, for example, in the Federal Act, there would be a definition of governor in council. And that's a phrase that occurs repeatedly in legislation, but you never see it defined anywhere except in the Interpretation Act. And basically the governor in council is another word for the cabinet. And when legislative powers are being delegated in an act of parliament, they are very often given to the governor in council. So when you read that in a statute, you have to read it with an understanding that governor in council is really the cabinet advising the governor general. That's the context for reading those words and understanding what they mean. As I mentioned a moment ago, there are a series of drafting conventions as well that have been developed by an organization called the Uniform Law Conference of Canada. And it's a federal provincial body that meets to try to develop model legislation that can be enacted across the country. But one of the things that it did was it tried to also develop a more uniform approach to the drafting of legislation. And so the drafting conventions of the Uniform Law Conference deal with things like the numbering system for legislation. It may seem like a trivial dimension to legislation, but actually numbering is a critical feature to the usability of legislation. One of the things that we do with legislation is we talk about it, we refer to it, and a numbering system makes it easy to pinpoint what you're talking about. It makes it easier to follow through, to locate where you are. And so things like that numbering system are part of the drafting conventions that have been adopted in Canada to make legislative text easier to use. So that's all part of this general context for legislation. The second element that Dreijer talked about was the grammatical and ordinary sense. And this is another absolutely critical feature of interpretation that has some very profound bases. One of the things Dreijer argued for, and successfully argued for, because it's been accepted by the courts, is that there's no specialized language for legislation. That laws are for the people, and and laws use the language of the people. They use the ordinary grammatical sense of language. They're not creating some new language. They're using the language that is used generally, and that is a reflection of the need for law to be understood by people. The law is for people. It should be written in the language that they understand. And so in interpreting the law, you're looking for a natural sense. You're assuming that the way the words are used is the way other native speakers of a language would use those words. You're looking at the ordinary rules of grammar. You're looking at what meanings are conventionally attached to words. And so you may look to a dictionary to see what ordinary usage is, because that's the dominant approach to interpreting legislation. It's not to say that sometimes the legislature may give some specialized meanings to words, or it may create some specialized rules of interpretation. But the foundation of interpretation is really the ordinary language and the ordinary rules of grammar.
And then Drager talks about a whole bunch of extraneous considerations above and beyond the immediate context. What is he talking about really in that sense?
You're right. He talks about some more really elements of context that are above and beyond just the particular words that you may be interested in. And the first one of these was what he called the scheme of the act. And his point was that when you read a particular section, a particular paragraph of legislation, you're not reading it in isolation from the rest. What you're reading is something that is part of a whole. It has a function, a purpose, it's part of a larger function and purpose of the rest of that legislation. And so you really need to read it in conjunction with the other parts of legislation. And sometimes this is very clear when you're reading legislation. You see cross-references in one section to another section of the act. And that's an indication that you can't read this section alone. You really need to make sure you're aware of that other section. Another demonstration of how integrated the various components of a statute are is the definition section. Most legislation begins with a series of definitions, defined terms. These are words or phrases that are used throughout the rest of the legislation, and at the very beginning of it, a series of meanings is attached to them. And sometimes those meanings are necessary to make it clear which of the ordinary meanings is intended, or sometimes a somewhat specialized meaning may be given to it. But those definitions have to be read into all the rest of the legislation. So when you're reading a section later on, if it uses one of these defined words, you have to read that definition into that section as well. So that's part of the scheme of the act. That's part of the statutory context that you have to bring to bear when you're reading a particular set of words that might be of interest to you. The next element, actually the next two elements are somewhat related: the object of the act and the intention of Parliament. And the intention of Parliament is an indication of what Parliament is trying to accomplish here. What's the legislature trying to accomplish? Because that objective may help you to understand exactly how these words are to be understood and how exactly they're to be applied. The words aren't put together on a random basis. Laws are passed to achieve something, to achieve some socially desirable goal. And having an understanding of that goal is often very helpful, particularly when the words that are used are of a very general nature. Legislation sometimes uses fairly specific words, but sometimes it uses very, very general words. It uses a word like reasonable. Reasonable is probably one of the most frequently used words in legislation. Well, what does reasonable mean? If you go to a dictionary, it's not going to tell you what reasonable means. It will kind of get you in the ballpark, but it's not going to be terribly helpful. To understand what reasonable means, you need to understand what the act is about. because reasonable is what's reasonable to accomplish the objective of this legislation. So understanding that objective is critical to understanding what reasonable means in that particular context. And of course, there are all sorts of other general words that are used in legislation, and so it's in those circumstances where having an understanding of the objectives of the Act and the intention of Parliament is helpful. But you also have to be recognized that the object of the Act and the intention of Parliament may or may not be altogether clear either. Some legislation begins with a statement of the objects of the Act, or it may begin with a preamble, which is another way in which legislatures and Parliament try to give a sense of what they're accomplishing. But those statements themselves may be fairly general in nature, and one difficulty is that sometimes in a preamble or in an objects clause, the statement of objects themselves may not be entirely consistent. You may get objects that are sort of going in slightly different directions. And so which one of the objects is the one that you're supposed to use to interpret this section? There's a certain amount of judgment that's left to the reader to try to come to a conclusion about what the objects are. And then if you go to the concept of the intention of Parliament, in many ways that's an even more difficult concept. Intention at its root is something that is a very human quality. It's something that is in the mind of individuals when they do things. But a law is not made by an individual. Statutes are made by members of Parliament and senators federally, and they're made by members of the Assembly in the provincial and territorial legislatures. And so they're made by a group of people. Well, what's the intention of the group of people? How do you understand what their intention is? And really, in the context of interpreting legislation, the intention of Parliament is a somewhat artificial concept. It's there to help you try to understand what might be meant here, but you can't take it literally. And so what courts have done is they've tried to extract that intention from things like what the member of Parliament or the minister said when they introduced the bill, or they may try to extract it from some of the study papers or some of the evidence that might have been presented to a committee as it's deliberating on the bill, or they may try to extract it from the debates, from the things that members of Parliament said. But those are really just indications of what the intention might be. It's rare to find in any of them some definitive statement of what the intention is.
It sounds like statutory interpretation is more art than science, that some of these indicators could point in different directions in more complex cases at least. Is that true?
It is. There's very definitely an artistic, judgmental quality to it. But it's not entirely random either, because you're still working within the context of words that are used, words that have meaning, in the context of a language that has rules of grammar, within the context of a certain rationality that underpins legislation and that is indicated by what you can understand in terms of the purposes and the intention of legislation. So yes, there's a certain judgment to understanding the meaning of legislation, but that's not to say that we live in an Alice in Wonderland world where you can just give whatever meaning you want to the words. Now, one difficulty though that this artistic quality gives is that different people may arrive at different conclusions about what the meaning of a piece of legislation is. And so the way that is resolved in our legal system is that the courts are the ultimate bodies that decide on the meaning of legislation. So you have the legislatures and Parliament who decide on what the words are going to be, but what they mean is really a decision for the courts to make when people disagree about what the meaning of those words are. And that again is it's a fundamental feature of our system of law, fundamental feature of the rule of law, that you have law that originates through a democratic process, but it's nevertheless subject to an interpretive process that is controlled by the courts. And it's really the checks and balances of our system of government, and this is how they operate. And so the courts, this is why we began talking a few minutes ago about why the courts have developed rules and approaches. It's because they are the final interpreters of the meaning of legislation. Now, of course, that's not to say that after a court has made a decision on legislation that the legislature can't go and change the words. And in fact, that very often happens. The courts may arrive at a conclusion about what something means, and the legislature may decide, nope, that's not really what we wanted, and so they change the law. And then you have essentially a new set of words that go into that interpretive process, and then the question may be, well, did those words capture what the legislature wanted to capture? And ultimately it's up to the courts to decide that. Now, in law schools particularly, we spend a lot of time looking at what courts say about the meaning of legislation. But you also have to recognize that most interpreters of legislation are not courts. And that, for the most part, legislation operates without the intervention of a court to say what particular words mean. That essentially, courts intervene when there's a problem, a serious problem. And happily, with most legislation, it is interpreted without the need to have the courts involved. So it's interpreted, first of all, by the people who may be affected by it. They may get legal advice as to what things mean, but in an ideal world, they should be able to read the legislation written in the ordinary language, using the ordinary grammar, and they should be able to get an understanding of legislation from that. But also, words are interpreted by the government agencies that have to administer the law, and so over the last few years, particularly, you see more and more the role of these agencies preparing guidance documents and brochures and policy statements, interpretation bulletins, things to help citizens understand what the law is about. And in fact, it's through those kinds of ways that probably most people get an understanding of what the law is. They read a brochure, they read a publication that is a statement of what the law, or should be a reflection of what the law is. And so their understanding of the law is built on the basis of basically that advice that's given by others. But they don't always accept that advice, and ultimately, if they think the government is wrong in its interpretation, they can challenge that interpretation in a court, and it's up to the court to have the last word.
Thanks very much, Professor Keys.
You're very welcome.